Yes, nice to meet you. First of all, I would like to say a few words about the presentation of my sister, Magdalena Rzewuska. She had to present her presentation yesterday, but she couldn't connect with the program, so I want to say a few words about her presentation. The subject of her paper is the principle of the best interests of the child in the context of minor parenthood. The best interests of the child are a fundamental principle of Polish family law. First, I will introduce the concept of a child and the principle of the best interests of the child. The concept of a child in itself is not uniformly understood in national and international law. Various definitions of the term child are found in many legal acts. In the Polish legal system, the terms minor and young person are often used instead of a child. Olszewski attempts to develop a uniform definition of child. His research in this era revealed that creating a single universal definition of child is impossible. According to the author, the broadest and therefore most appropriate definition of child appears to be the one provided in the Act on the Ombudsman for Children, as it can be applied regardless of the child's position in society. According to this act, a child is every human being from conception until the age of majority. The legal definition of a child is provided in the Convention of the Right of the Child. The Convention states that a child means every human being under the age of 18, unless under the law applicable to the child attains the age of majority earlier. This definition is commonly used, although according to Olszewski, it seems to be insufficient and impressive because it does not specify whether a child is from birth or from conception. Olszewski points out that the child is a child even before it's born. However, according to Lewandowska, defining the initial moment of being a child seems impossible at a universal level. Although the Constitution of the Republic of Poland does not provide a definition of a child, based on the provisions contained therein, a child is defined as any person under the age of 18. Under the Constitution of the Republic of Poland, doubts arise as to whether a nasciturus is also a child. The literature has highlights differences between the provision of the Constitution of the Republic of Poland and the provisions of the Civil Code and the Family and Guardianship Code regarding the concept of child. In family law, a child is identified as a minor under parental authority. Under the Constitution of the Republic of Poland, being under parental authority is not a determinant of being a child. Under the provisions of the Civil Code in conjunction with the Family and Guardianship Code, an adult is also a woman who has reached the age of 16 and who has entered into a marriage with the consent of the family court. Under the Constitution of the Republic of Poland, such a woman remains a child, which means, for example, that she remains obligated to attend school and is entitled to parental care and assistance from public authorities in the event of her parents' refusal. Based on the provisions of the Family and Guardianship Code and the Civil Code, it should be recognized that a nasciturus can also be a child. This stems from the term conceived child used in both of these normative acts. One should agree with Olszewski that the most appropriate definition of a child seems to be the one included in the Act of the Ombudsman for Children. The best interest of a child is a vague concept. Its interpretation by the court should be individualized to each specific case. This concept gives the court considerable latitude in interpretation and the ability to rely on extra-legal norms when issuing rulings concerning children. Although the vague formulation of the best interests of the child allows for the flexible adaptation of the conceptual category to a specific situation and the protection of children's rights to the fullest extent possible, taking into account circumstances unknown to the legislator, it also generates practical difficulties in understanding this concept by judges, experts cooperating with the court, parents, legal guardians appearing in court proceedings, and representatives of other provisions involved in caring for the well-being of children. As the Constitutional Tribunal notes, the best interests of the child constitute a specific constitutional general clause, the reconstruction of which should be based on constitutional axiology and general systematic assumptions. The order to protect the best interests of the child constitutes a fundamental overarching principle of the Polish family law system, to which all regulations in the sphere of relation between parents and children are subordinated, including legal mechanisms concerning filiation issues. The best interests of the child are also a value that determines the shape of other institutional solutions, primarily those within the family and guardianship code. It also highlights as a special value in the provisions of the United Nations Conventions on the Right of the Child, ratified by Poland. The case law notes that the fullest realization of the principle of the child's best interest can be achieved by ensuring the child's upbringing in a family, primarily in the natural family, that is through parental care provided by persons connected to the child by biological bonds. The principle of the child's interests expressing the primacy of bonds based on actual biological origins, thus expresses only a dominant tendency, which does not exclude the possibility that under consent conditions and circumstances, the child's best interest will require recourse to other premises for shaping family relationships within which the child's interests will prevail over the interests of biological parents and will require the protection of family relationships based on the existence of a type of bond other than the biological bond. This stems from an understanding of the child's best interests that primarily emphasize the minor's interest in ensuring appropriate conditions for upbringing and development. Attempts have been made to define the child's best interests in the literature. According to Kłodziejski, the child's best interests are a set of values, both spiritual and material, that are necessary for the proper physical development of the child, spiritual development of the child, both intellectually and morally, proper preparation for the work for a society. According to Radwański, the child's best interest consists in achieving states of affairs that promote their physical and spiritual development in such a way that they are properly prepared to work for the good of society in accordance with their talents. Furthermore, care for the child's property should also be taken into account in actions that promote the child's best interests. In Szynkowski's opinion, the child's best interest constitutes a contemporary and guiding principle of family law in the context of the child's optimal development through parental bonds with parents in their natural environment, which is the biological family or in foster family. When assessing the best interest of the child, both objective criteria should be taken into account. For example, the age, gender of the child, the character traits of the parents, and the relationships with each other, as well as subjective criteria, for example, the degree of sensitivity of the child, the relationship between parents and children. It should be stated that it would be impossible to create a single universal definition of the best interests of the child, if only because in each case the age and individual needs of the child determine his or her best interest. Although the principle of the child's best interest is a fundamental principle of family law, it appears that the legislator, under the provision of the Family and Guardianship Code, does not approach it uniformly. It's completely unclear when a 16-year-old mother who enters into a marriage with court permission is treated as an adult and is therefore granted parental authority, while a 16-year-old mother who is not married is treated as a minor and therefore does not have parental authority over the child. This is all the more surprising because even if a 16-year-old mother marries, she attains adulthood and does not lose it even if she divorces her husband at the age of 17. Such a legal solution does not seem to be consistent with the principle of the child's best interests. This is especially true given that minors have limited legal capacity, while adults have full legal capacity. In this context, the regulations that allow a 16-year-old to be recognized as a father are also surprising. Such a man can recognize paternity while still legally considered a minor and therefore one who will not have parental authority over his child. The impact of such regulation on the best interests of children is astonishing. And that was the presentation of Magdalena Rzewuska. Now I will present my paper. And the subject of this paper is an attempt to explore the issue of inheritance for women in civil partnerships. The comments made are somewhat abstract in nature within the context of Polish law, to which I refer, as this law does not provide for an institutionalized civil partnership. Therefore, the issue of inheritance for parents also appears to be general and open-ended. However, the conclusions drawn from the research take into account existing Polish draft laws on civil partnerships, as well as international legal solution in this era. In the literature, a distinction is made between the concepts of registered partnerships and civil partnership. The former is used to refer to all formal relationships, alternatives to marriage. This term is general and diverse, depending on the legal regulation adopted in a given country. It may apply to same-sex couples or may not impose any restriction in this regard. In practice, registered partnership is known under various names, such as civil pact of solidarity, a civil union, or civil partnership. The term civil partnership, on the other hand, refers to any personal relationship other than marriage, usually between same-sex couples. In legal literature, the terms cohabitation and informal partnership are used interchangeably. Formal civil partnerships are currently permitted in many European countries. These include Germany, France, the United Kingdom, Ireland, Switzerland, Austria, Belgium, Netherlands, Luxembourg, Sweden, Norway, Finland, the Czech Republic, Hungary, Slovenia, and Malta. Similar regulations have also appeared in North America, South America, Africa, Australia, and New Zealand. Among the European Union members, the possibility of entering into an institutionalized civil partnership has been excluded in Poland, Bulgaria, Romania, Slovakia, Greece, Croatia, Lithuania, Latvia, Estonia, Cyprus, and Italy. In comparative law, three basic types of registered partnerships can be distinguished: contractual partnership, marriage minus, and quasi-marriage. This classification is based on the extent of similarities and differences between these partnerships and marriage. Contractual partnership, as the name suggests, is strictly contractual in nature. Typically, such a contract legally guarantees partners specific rights and obligations that are granted to married individuals. On the other hand, contractual partners are free to determine their mutual property relations. Contractual partnerships are regulated in countries such as Belgium and France. Marriage minus, in principle, constitutes a registered partnership between same-sex couples. Such a union grants partners a wide range of property rights and obligations similar to those of spouses. The main differences between marriage minus and traditional marriage concern the personal relationships between the partners, particularly the relationship between parents and children. Such solutions have been adopted in countries such as Germany and Switzerland. In turn, the primary purpose of quasi-marriage is to provide partners with rights and obligations equivalent to those of spouses. This essentially applies to both property and personal matters. Nordic and Dutch legislation has adopted appropriate solutions in this regard. According to Article 515 of the French Civil Code, a contractual partnership, or more precisely, a civil solidarity pact, refers to an agreement between two adult persons entered into the purpose of organizing their life together. This type of contract may be concluded regardless of the gender of the potential parties. Article 515 of the Code imposes on partners a statutory obligation of mutual financial support, which accrues the marital obligation to support each other. Beginning in 2006, the first regulations concerning inheritance law were implemented in France for partners. Specifically, it stipulated that unless the deceased person expresses a different will in their will, the partner acquires the right to free use of a property owned by the deceased of both parties. This right also covers household appliance located in the property. This right is limited to a one-year period calculated from the date of the opening of the deceased partner's inheritance. The condition for exercising this right is that surviving partner resides in the property at the time of the partner's death. Furthermore, such property must be the primary residence. In a situation where the deceased was only a tenant of the premises, the other partner may claim from the heirs the reimbursement of rent due for a period of 1 year from the date of opening of the inheritance. Furthermore, under an appropriate testamentary disposition, the surviving partner may be granted ownership of a property to meet the housing needs. As with statutory succession, for this testamentary disposition to be effective, the surviving partner must reside in the property at the time of the death of the other party to the agreement. Contract partners are not granted any other inheritance rights. Furthermore, it's important to remember the reserve system in force in France, which introduced further restrictions on the freedom to dispose of assets post-mortem in favor of the partner. In Germany, partners are legally obligated to provide mutual care, support, and cohabitation. Entering into life partnerships creates almost familial bonds between the parties. In 2004, German lawmakers brought the regulations governing property relations between partners closer to those governing marriage. This had a significant impact on inheritance law. Currently, German partners inherit under principles similar to those governing spousal succession. Life partners are among the legal heirs. Furthermore, they are entitled to the so-called statutory provision of superequity, known under the Polish law, which applies to everyday items in the shared household. It should be emphasized that the surviving partner is also entitled to a claim for compulsory share in force under principles similar to those for a spouse's compulsory share. Furthermore, partners like spouses are entitled to joint testamentary rights. Switzerland is another example of a country where registered partners are granted property rights similar to those of spouses. Partners on an equal footing with spouses are obligated to contribute to the maintenance of the community established between them. Under inheritance law, Swiss registered partners generally have the same rights and obligations as spouses. Therefore, they not only have the right to inherit from each other ex lege, but also enjoy the status of so-called necessary heirs. The Nordic construction of a registered partnership boils down to granting partners equal rights and obligations in property law to those accorded to spouses. This also applies to inheritance law. Similar solutions have been adopted in the Netherlands, according to Article 181 in conjunction with Article 180 of the Commercial Companies Code. A registered partnership creates the same rights and obligations between partners as between spouses. Partners are obligated to provide each other with both personal and material support. This had a corresponding impact on the legal inheritance relations between partners. They are entitled to statutory inheritance and the right to use the previously occupied home after the death of one of the partners. Like spouses, Dutch partners are not entitled to a compulsory share of each other's property. Although Polish law does not provide for a formalized institution of a personal union as an alternative to marriage, it cannot to be ignored that attempts have been made in the past to regulate the legal status of partners. Without providing detailed analysis of Polish bills concerning registered partnerships, this section will address issues related to the title topic. The first initiative to institutionalize civil partnerships in Poland was the Draw Act on Registered Civil Partnerships of December 10, 2003. Drawing on Nordic legal solutions, it represented the most liberal approximation of a civil partnerships to a traditional marriage. Article 6 of the proposed act stipulated that partners would inherit from each other in the same way as spouses. The aim of the regulation was to ensure that partners had the same rights and obligations regarding inheritance as spouses at the time. Another initiative was the Draw Law on Registered Same-Sex Partnerships of December 2004. According to Article 14 of the Draw, partners, like spouses, would have the right to inherit from each other by statute. However, they were not granted the right to a reserved share. The most recent attempt to regulate civil partnerships was the Drawn Law on the Civil Partnerships Agreement of August 29, 2012. Under the proposed Article 15 of the regulation, after 1 year from the date of conclusion of the Civil Partnership Agreement, partners would be entitled to inherit from each other by statute under the same rules as spouses. The rationale for this solution was to grant marital inheritance right to parties to durable civil partnerships. A linguistic interpretation of the provision questioned whether such an equalization of partners with spouses would include granting the former partner the right to a reserved share. Due to the fact that the Polish legislature ultimately decided not to adopt any of the aforementioned draft laws on civil partnerships, only informal partnerships currently exist. This has a corresponding impact on legal and inheritance relations. Under Polish inheritance law, habitants are not entitled to inherit from each other ex lege. Despite their personal relationship and emotional bond, often accompanied by specific material dependence, they have not been included in any of the categories of statutory heirs. This means that in the event of statutory succession, the surviving habitant will be excluded from inheritance by a relative of the partner who can be assigned the status of the heir. It should be noted that the parties to an unregistered partnership have also been deprived of further significant inheritance privileges. They are not entitled to the reserved share of the deceased partner's estate, nor even to a super-divisional bequest, which includes the right to use the apartment jointly occupied with the deceased partner. In other words, the only way to transfer assets to a partner post-mortem is to designate them as heirs through a will. In such a case, however, there is always the risk of eligible family members of the deceased partners asserting a claim for the reserved share against the surviving partner. Of course, other willful dispositions, such a bequest or an instruction, may also be considered. However, due to the limited scope of such dispositions and the previously mentioned potential risk of a claim for the reserved share against the partner, they do not appear to be an effective solution to the problem of inheritance between partners. The doubts surrounding the title issue are certainly not resolved by the possibility of making gifts between parties to a cohabitating partnership. This would, of course, be different in the case of donatio mortis causa, which, however, is not provided for by Polish law. It therefore appears that without a delayed statutory solution, the applicable provisions of inheritance law will in many cases be unable to implement the actual will of a testator in a civil partnership. In light of the established position of the judiciary, applying matrimonial law provision by analogy to cohabitants is not permissible. As an example, it's worth citing the Supreme Court judgment of December 6, 2007, which held that the settlement of property after the termination of a de facto personal and property relationship of persons of the same sex shall be based on the provisions of the Civil Code appropriate to the specific form and content of the relations established in a given relationship. The justification for the ruling emphasized that the protection of marriage provided for in Article 18 of the Constitution means that legally legalized union between a man and a woman remains under the protection and care of the Republic of Poland. Of course, it is beyond dispute that individuals in informal partnerships, regardless of gender, can enter into various types of agreements. For example, a partnership agreement, a series of unnamed agreements, etc. Although such agreements will have limited financial consequences between cohabitants, they cannot effectively reflect the specific nature of partnership property ties. Therefore, it's difficult to assume that the possibility of concluding such agreements guarantees partners fully satisfactory legal protection, primarily regarding property. A similar view was expressed by the European Court of Human Rights, which supported the need for states to create conditions for the legal recognition and protection of same-sex couples' unions. Furthermore, it's difficult to require the parties to an informal partnership to comprehensively regulate all the current and potential property matters within one or more agreements. As a rule, partners will not be aware of all the legal consequences related to their situation. Applying a permissible civil law mechanism such as unjust enrichment to mutual settlements between partners does not therefore seems to resolve all the related problems, especially those related to inheritance law. Furthermore, in practice, even in inter vivos transactions, serious doubts arise regarding the applicability of these legal contracts to cohabitants. For all these reasons, the thesis that there are insufficient arguments for applying existing legal solutions to partners seems fully justified, as does the demand for implementing a specific regulation regulating title relationships and, above all, the issue of partnerships inheritance. And thank you very